And welcome to the Legal Lounge on CRN Digital Talk Radio, crntalk.com, streaming live coast to coast and around the world in stunning high-definition video on facebook.com/CRN Talk, on CRN's custom-built Roku channel, Tiki Live, and of course on crntalk.com. I am joined, as always, by the one and the only active attorney, U.S. Army veteran, Juris Doctorate in Law, undergraduate degree in physics, and author of a book that has proven to be a guideline for the Supreme Court now and in the future. That book, America, An Illusion of Freedom, is available on Amazon.com, Barnes Noble, on iTunes. Check him out on AM 870 The Answer. Ladies and gentlemen, it's Mr. Richard Nixon, and the show that gives you the news you get nowhere else. How are you, Richard?
I'm just fine. I have just a bit of international news, and I understand you have some local news for us. But in any event, the national news or international news that I have is simply that we have a new pope. I was hoping he would be or is Italian. The best part about it, though, is he was born here in America, of all places, Chicago. And I understand he's always voted Republican. Wow. With our President, Mr. Trump, and our Polish Republican Pope, we're on our way to a threesome, and we're going to do some great things.
Yeah, first American-born Pope in over 2,000 years of the papacy, and hopefully in Rome he's getting some nice Chicago-style deep dish pizza and some Polish dogs and Italian beef sandwiches. Also, we have a little sad news to report. We have Associate Justice David Souter has passed away at the age of 85. A highly intellectual Supreme Court justice, of course, and he will be missed.
He will be, but I'm sorry, I have something kind of, it's factual, but it's a little negative regarding Mr. Or maybe it's positive. Mr. Souter was appointed by senior George Bush, the father, President Bush. He was picked because he was a real conservative, but as time went on, he did an about-face, and he became one of the court's maybe the most intellectual, if you will, but he was liberal all the way through.
Yeah, that happens a lot sometimes, especially with judges with senior status. They get a little bit, the trappings of the office and the drivers and the cocktail parties and all that.
They realize they're the last word, so they can do what they want. They can unrestrict themselves, and they do.
They can. They're really not held accountable. Also, some good news, Richard. A friend of the show.
Yes.
Judge Jeanine Pirro, of course, the Fox News fame and a former prosecutor in New Jersey in Essex County. She has been named.
Yes.
President Trump has named her interim United States Attorney for D.C.
And I can't tell you how many times I've watched her, and she would be talking about a particular case, and she would say, now, if I were the prosecutor on this case, this is exactly what I would do, and I don't understand, So now she's primed for it. She knows what to do. She's always known what to do in the legal realm, and I'm glad to see she was picked by Mr. Trump to do something great.
I mean, that U.S. attorney's role, for the D.C.
Oh, absolutely.
That's an important job. I mean, she's been a staunch defender of President Trump, been a staunch defender of those involved in January 6th. And, a lot of those cases that Mr. Trump, some might say have been, railroaded has been through that D.C. Circuit Court.
That's right.
And so it's going to be very interesting to see. So congratulations to Judge Jeanine. There's an open spot now in the 5. So Richard, keep your phone on.
I'm going to do it.
They might be calling you. We're going to have a great show, you guys, today. We're going to talk a lot about President Trump's executive orders. Big day coming up on the Supreme Court, May 15th. You're going to hear oral arguments about the birthright citizenship case. We're going to talk a lot about attorney's fees and preliminary injunctions and how that might affect those executive orders moving forward. Also, Richard has an expert treatise on clean hands doctrine and how that might apply to both immigration sections 1227 and 1182. So stick around, you guys. We're here in the Legal Lounge, CRN Digital Talk Radio, crntalk.com. You can listen to us anytime by shouting at your Amazon Alexa, play CRN1, and we'll be right back. Stay with us. And we are back in the Legal Lounge, CRN Digital Talk Radio, CRNTalk.com. You can find us anywhere on the web. You can also find us on Roku and on Facebook. Search Roku Store for CRN Talk. Search Facebook for CRN Talk. Search X for CRN Talk. We are everywhere. And Richard, we've seen President Trump come into office day one, hit the ground running, and he campaigned on a lot of different issues, and he wants to make these issues happen for his constituency. He's doing so because one of the topics of our show and our book, and your great book, fantastic book, American Illusion of Freedom, is that Congress doesn't like to do too much work, is that he had to do a lot of this stuff through executive order. And
exactly.
So what is an executive order? An executive order is a directive by the President of the United States that manages operations of the federal government. The legal or constitutional basis for executive orders have multiple sources. Article 2, that gives the President broad executive enforcement authority to use his discretion to determine how to enforce the law or otherwise manage the resources and staff of the federal government executive branch. The delegation of discretionary power to make such orders is required to be supported by an expressed or implied congressional law or the Constitution itself. So Mr. Trump has used a lot of these executive orders. And we read, and you and I have read these executive orders.
Yes.
And he always cites a relevant code section that
Absolutely.
relates to the executive order taking place. However, the courts, that unelected branch, usurping our freedoms,
right,
they have stepped in all along the way to put the kibosh on a lot of these executive orders.
Yes.
Specifically through preliminary injunctions, even more specifically through these nationwide preliminary injunctions.
Well, let me boil down. You gave us a very formal definition of an executive order, but let me give you kind of a boiled down thing that does mention something very interesting. It is a directive issued by the President of the United States that directs the federal government to take specific actions. Now, it has the force of law, but it doesn't require congressional approval. That's the beauty of it. He does it on his own. Executive orders are often used to implement existing laws or to direct how agencies should carry out their duties. So in general, like you were just saying, Mike, the president will find a law that he wants to enforce or must enforce under the Constitution, and he fashions an executive order that will do just that. It enforces the law that Congress has passed. And what's happened in our country since President Trump is that he has done something like 85 executive orders, and I think every one to the man has been opposed by the left. So we've got maybe 85 executive orders and 85 TROs basically holding it up, and with the help of federal district court judges who happen to be on the left, apparently, they have granted the opposition or the temporary restraining order against Mr. Trump, so they are all being held in limbo. However, the Supreme Court has, to a certain extent, come to the aid of Mr. Trump by talking about attorney's fees for preliminary injunctions. Should we go there?
Yes, please.
Okay. In general, what we've got is a situation where in April of this year, the Supreme Court held that plaintiffs who obtain a preliminary injunction, which is the same as a TRO or temporary restraining order, are not eligible for attorney's fees under this particular section, 42 U.S.C. 1988 small b, because they do not qualify as prevailing parties. Now, for those of you who want to look at the case itself, it's Lackey versus Stinney. Lackey is spelled Lackey versus Stinney is spelled Stinnie. Chief Justice Roberts, writing for the court, explained that obtaining a preliminary injunction does not confer prevailing party status under 1988. The court reasoned that preliminary injunctions do not provide enduring judicial relief on the merits. So in other words, it's not a final judgment on that particular case. It is simply an intermediate type or an initial hearing or issue granted or order granted by the judge. Therefore, the court says you are not, if you're the plaintiff in this preliminary injunction thing and you prevail, because it does not have a lasting effect, it might be overturned eventually, there are no prevailing parties, and therefore the plaintiffs do not qualify for attorney's fees.
Yeah, so brass tacks here is, vis-a-vis these executive orders. So the hypo here is that it's more than a hypo because it's happening in practice. Is because you have these attorneys, these law firms, oftentimes supported by shadowy leftist organizations, will come in and they will defend a certain class or persons that are subject to some of these EOs.
Yes,
and they'll get the TRO.
Yes,
but what Judge John Roberts says and the court says is like, look, Mr. High, law firm, you guys can't get paid and just because you won this TRO. You have to take this all the way till it's the case's conclusion.
That's right.
Which might take years.
That's right.
And so this might actually have a cooling effect on some of these attorneys trying to make a quick buck off these executive orders. Is that what pretty much was going on?
Well,
here?
that's why I'm saying that the president of Chief Justice Roberts has, in a sense, done President Trump, a favor by saying that, in effect now, we don't know how many of these 85 preliminary injunctions that have been granted. I don't know how many have already received their monies or if that's in the throes of it. In any event, any new cases, certainly, even if they win the preliminary injunction, they do not qualify for attorney's fees. Now, we were talking at our show prep that Mr. Trump and his attorneys, if they're very clever, they could simply rewrite some of the 85, but change the wording just a bit so that now you would expect that they're going to get opposition to that new executive order, let's say number 86. But are we going to get any opposition when we know that the opposition's counsel will not be paid? They will not get attorney's fees. And what's the significance of that? That is this. Trump files an executive order, number 86, let's say. Nobody opposes it. And what happens? It becomes law. And that's exactly what Trump was. So now whether or not his attorneys are that clever or that sneaky, if you will, and we don't know how many of those 85 plaintiffs' attorneys have been paid yet. Maybe none of them have. But the point is, this all inures in the favor of Mr. Trump and possibly keeping valid these executive orders that he's already filed.
Well, we've talked to, and Senator Josh Hawley and Tom Tillis and others have said that these nationwide TRs are not above board.
That's for sure.
Because you have one judge out of one far left district way out there in the middle of nowhere making pretty much policy for the entire nation. I mean, you've written about that in your book. I mean, that's the illusion of freedom.
Not only that, but under Article 3, the only judge that is in the Constitution is the Supreme Court. That is the only tribunal, I should say, of all the judges that are in the Constitution. Article 3 mentions the Supreme Court. All the other judges and justices are picked or nominated or voted in by Congress. So what we've got now is a president who is suggesting an executive order. He wants this law to be the law. We have someone who does not even appear in the Constitution opposing that judge and literally, opposing the president and actually holding him at bay until another judge might decide the issue.
Yeah, which can take months, if not years. Stick around, you guys. We'll be right back right after the break. Stay with us. are back in the Legal Lounge. Once again, thank you so much for spending some time with us. We appreciate that. All past and previous sessions of this high-quality broadcast are available on Facebook at crntalk.com/Facebook. Also on YouTube, you can find Richard's playlist at CRN Digital Talk Radio on YouTube. Also on Rumble. Check us out there. And also make sure to check out his fantastic book, America, An Illusion of Freedom. Available Amazon.com, Barnes & Noble, and on iTunes. All right, Richard, let's just get into a couple of these executive orders.
Yes.
First one, has to do with the Venezuelans. This was an executive order where President Trump denied entry to and deportation of Venezuelans because of the Enemies Alien Act. Of course, the lawyers for the American Civil Liberties Unions filed urgent requests in multiple courts, including the Supreme Court, urging immediate action after reporting that some of the men were loaded on buses and told they would be deported. The Supreme Court on April 7th issued a decision allowing the administration to remove Venezuelan migrants or under the Enemies Aliens Act, but specified that that notice must be afforded within a reasonable time and in such a manner that would allow them to seek habeas relief. What do you think about that?
Well, again, I think that Illegal Aliens Act is constitutional. I think that what Mr. Trump is doing is perfectly proper, because it's my understanding that these people are known. I think they were brought in by, if you will, President Biden. They were pretty much identified. I think they probably had their, quote, due process when they were prevented from coming in the first place. Now that they want to be deported, I think they should not be able to take advantage of the Constitution, assuming that they could. Because if one reads the Fifth Amendment due process clause, no person shall be denied as life, liberty, or property without due process. None of these people have been denied. They don't have any property interest here because they have no right to be here if they're here illegally. So there is no due process due them. And if there were, they would have already received it when they were, if you will, denied entry in the first place. There's several different groups of Venezuelans that are arguing here. We also have one in the temporary situation.
The temporary protected status.
Exactly. And so that's also kind of gone by the against Trump, at least temporarily. And so we've got some conflicts between what one judge is doing and what the court is doing and so on.
Now that you've led us down this path, Richard, I want to get into this a little bit.
Okay.
So I'm not clear in my mind.
Yes.
Because we have 8 U.S.C. 1182 grounds for inadmissibility. So this is somebody that's not in the country.
Correct.
And some of these grounds for inadmissibility is health-related conditions, national security concerns, important, criminal records, important, likelihood of becoming a public charge, important, and unlawful presence, i.e. coming here illegally. Prior illegal entry to the United States. So these people, they're not entitled to due process because they're outside of the country.
Correct.
But yet you have 8 U.S.C. 1227 grounds for deportability. Those are people here already in the country who came here illegally, crossed the border illegally in violation of federal law. And the grounds for deportability are criminal convictions, or violations of visa conditions, security threats, immigration fraud, so on and so forth. They are allowed to have due process according to.
Well, okay, we could maybe peacefully, properly discuss this, Mike. The 8 U.S.C. Code 1227, deportable aliens, does say that if, upon the order of the Attorney General, they may be removed if the alien is within one or more of the following classes of deportable aliens. Number 1, inadmissible at time of entry or of adjustment of status or violates status. So the point is, if they were here, but they would not have been permitted to enter in the first place.
Yeah. So
they're here in violation of the law. And as we've talked about before, Person 1182, Section 1182, small f of Title 8 says the following. Whenever the president finds that the entry of any alien or of any class of aliens into the United States would be, listen to this, detrimental to the interests of the United States. That is so wide open.
Very broad.
He may, by proclamation, which simply means that he has to make some kind of a public address.
Putting pen to paper,
to that effect. And for such period as he shall deem necessary, suspend the entry of all aliens or any class of aliens as immigrants or non-immigrants, or impose on the entry of aliens any restriction he may deem to be appropriate. Now, the point is, since the president has that absolute carte blanche to keep people out of this country, if you have a situation where the president has already spoken on a particular individual or class of individuals, as in some of these Venezuelans, and that those people come over, they break the law, they come over into this country, and then they say, hey, there's a Constitution here, and the Constitution, at least the Fifth Amendment to the Constitution, says all persons have a right to no, the government shall not deny a person life, liberty, or property without due process. So he's saying, where's my due process? And my answer to that is twofold.
Hold on. Hold that thought, Richard, because I want to give you more time. We're right up against a break. We're going to talk more about this. This is a fascinating discussion. Stay with us. We'll be right back. And we're back at the Legal Lounge. Once again, thank you so much for joining us here. And Richard is educating me and listeners about due process rights, because I was unclear in my mind, as I said before, is that you come to this country illegally and then you're caught. People say you are eligible for due process.
Yes.
Yet, if you are not in this country yet, but you want to come, you're not eligible for due process.
That's right. Now, so what I was getting at is you come to two objections that I have with granting due process to this person who was originally denied entry but who is now in the country. And now he's saying, hey, I'm here, and according to the Constitution, I have a right to due process. Now, what is due process? Basically, it is a notice and an opportunity to be heard. Now, two reasons why I oppose giving these people any more due process is because they've already had the due process. When they were told that they were going to be denied entry, or they were in fact denied entry, they got due process right there. So in spite of the fact that they were denied entry, they came across anyway, and now they're claiming that we, because we're so gracious in this country, we're going to grant these people who violated the law by coming into the United States, they want some constitutional rights. Now, 1182, F has also said that people who are illegal, who are not citizens or not permanent legal residents here, have no constitutional right to property or equity or liberty interest. They have no such interests in this country because they are not properly here. Therefore, they're not entitled to due process. And in any event, they've already received due process when they were prevented from coming in the first place. One last thing I want to mention on that. If this kind of situation were to be presented it's going to be by our girl from New York now, Pirro.
Yeah.
If that were presented to her, she would say, wait a minute, you were already told that you're not to come in here because of 1182. The president said you cannot come in. Now, you're here now and you're asking for due process rights. You have broken a law in order to get here, and now you're asking for due process rights. And the idea comes up with what they call, or what is called, clean hands.
Now, in clean hands, that's a doctrine. That's a court doctrine.
It is. And what it's going to say is that if you're here and you have done something improper, illegal, when you're asking for the court for some relief, the court can properly deny it based upon the fact that you were not here with so-called clean hands.
Because, clean hands, sometimes the clean hands doctrines, unclean doctrines, or dirty hands doctrines, an equitable defense in which the defendant argues the plaintiff is not entitled to obtain an equitable remedy because the plaintiff is acting unethically or has acted in bad faith to respect of the subject of complaints. And we're using plaintiff here because oftentimes it's when during an appeal process. So, if I'm an illegal alien and I come to this country illegally, break the law, I'm now subject to order of deportation, and I go to court saying this is unfair, my hands are unclean because, anybody in the world, Richard, just has to know that coming to this country undocumented through, not the standard protocols of immigration to the United States is illegal. So, I mean, I don't understand why this clean hands defense hasn't been talked about more in the media or in the courts in general during these immigration hearings.
Well, because technically it's not, excuse me, the law. The law is something that's supposed to be interpreted strictly, and each judge takes an oath to follow that law. Mm-hmm. However, ethics kind of crept into it during our days back in England, where the king would be making all these decisions. But on the other hand, well, let's say a person was in there before the king for having stolen a loaf of bread.
Okay.
And there's a punishment for that, maybe 6 lashes. The king could look at that and say, but you know what, why did you steal the bread? Well, because my family, my wife and 17 kids were starving to death. Well, the king could say, well, you know what, I think you've got a good excuse. We're going to dismiss the charges. So clean hands or unclean hands is just kind of an ethical idea. And I don't know that there would be a law that simply said that if you were told that you could not come into this country for good reason by the president, but you come in anyway and break the law by doing so, there's probably no law that basically says, and now when you ask for due process, you're going to be denied. No, this would be probably a situation where the court could exercise its judgment and simply say, no, based upon your unclean hands, you are not entitled to the protection of due process.
But like you said, too, if when you come to a point of entry in this country, I mean, you talked about it in our show prep when you're coming back from Mexico. Me too. I mean, they
yes.
You show your ID or your passport.
Right.
If you circumvent that process, because that's due process right there. That's you.
Good point,
That's
Mike.
you going to an agent in the federal government who's protecting the border, and you're saying, I am who I am, and I'm a U.S. citizen. I can come into this country. And he says, yep, your ID looks good to me. Come on in.
Right.
That's due process.
That's right.
But if you knowledgeably and with malice circumvent that process by going over, in the middle of the desert, crossing the border and jumping the fence illegally,
right.
You in your mind, mens rea, you've known that you have circumvented that due process.
You got it.
So therefore, maybe you should be entitled to that due process.
Exactly.
Oh, that's a good one, isn't it?
Well, one other thing we can add to it, in case we need another argument for Chief Justice Roberts, is if you read the Fifth Amendment, it applies to Congress. There is nothing in there that says that the president is bound by any kind of due process. Now, that might sound authoritative, or
despotic.
It might sound, okay, what's the other word I'm looking for? Well, anyway, too severe for the president. However, as we've talked about before, we cherish the president because our first president was Washington. He could do no wrong. And so the Constitution, quite frankly, is written for the protection of the president, except for one thing. If he does, that is, the president does something so egregious that the whole country wants to get rid of him, we have the impeachment clauses, and it takes the whole or half of the House of Representatives, not just one prosecutor, but the whole House of Representatives, the half of them, must vote to impeach him for whatever he's done, and then 2/3 of the Senate must vote to remove him.
Yeah, because, I mean, in President Trump's case, or any president for that matter, they have secured millions and millions of votes. And in order to turn over the will of the people to kick somebody out of office who they've chosen to be president through their franchise.
Exactly, and I like the way you put it, Mike. All these people voted him in, and now one prosecutor is going to remove him?
Yeah, that's not how it works. Stick around, you guys. We're right back. We're going to talk about the big May 15th oral arguments in the Supreme Court. Stay with us. And we are back in the Legal Lounge. We teased it before, but May 15th, mark your calendars, folks. The Supreme Court, it's going to be a real barn burner. We're going to hear the birthright citizenship oral arguments in front of that Supreme Court. And, you can listen to it after the fact on oyas.org or on the Supreme Court website, read the transcript. But C-SPAN, I love C-SPAN. C-SPAN has asked the court, petitioned the court to actually carry it live on television.
Yes.
Never been done before. Doubt the Supreme Court will allow it to happen, but I'd like to see it personally.
Right.
I mean, we want to see, Justice Thomas, kind of side eye some of the justices, and you want to see their body language and their inflection.
I want to see him smoke a cigar.
I would like to see that too. And I've been listening to a lot of these oral arguments, and Justice Thomas has been known to be a little bit quiet. He's getting a little bit more loquacious.
He is.
He's interesting. But anyways, the birthright citizenship EO President Trump signed shortly after he took office, where he wanted to end the policy of birthright citizenship. And this is now heading to the Supreme Court to hear those oral arguments. And, this is not the first time that the birthright citizenship issue has been at the Supreme Court, of course, going all the way back to the Dred Scott decision. But a case that is often cited in these issues, Richard, which I think you and I both agree is dead wrong, is this Plyler versus Doe.
Yes.
And the Plyler case was in 1982. Please talk us about this case, and especially a blazing hot dissent.
Well, Mike, can we introduce the 14th Amendment first,
please,
the birthright citizenship? And the reason I wanted to cite this is because although it apparently was written or at least signed by President Trump, it seems to have some Jeffersonian tones to it because it says here the purpose. The privilege of United States citizenship is a priceless and profound gift. Now that is Jeffersonian all the way. Even when you read the Declaration of Independence, he actually makes an effort to let the people know why we are separating from England. Instead of just doing it and having a revolution, he says that, I wish I could remember the words, but he says that generosity and our role in the world, and it demands that we explain to everyone exactly why we're doing. I mean, what a stroke of generosity. Anyway, or propriety. What Mr. Trump goes on to say that the 14th Amendment states that all persons born or naturalized in the United States, and this is the important part, and subject to the jurisdiction thereof, are citizens of the United States and of the state wherein they reside. Now, the important part of this is this. The debate coming up May 15th is the term, and subject to the jurisdiction thereof. Many people, especially lay people, will read this and say, oh, okay, the person's born here, and so they're subject to our jurisdiction. That's fine. You're just kind of redefining that person, and they're citizens. Fine. Now, the only problem with that is that we attorneys have we don't go by strictly grammar that you learned in school. We have what are rules of construction to interpret what someone else might have meant when they said X. Now, first of all, we have one rule that says that we deem that the person who wrote this, or the people who wrote this, Congress, back in the day, they meant what they said, and they did not believe in writing anything or putting anything in one of these legal documents that was unnecessary, redundant, superfluous, and so on. So when we look at this and it says a person's born here and subject to the jurisdiction thereof, we have to inquire, what did they mean by and subject to the jurisdiction thereof? Well, again, Ted Kennedy of Chappaquiddick fame and so on, he said, well, it means the same thing. He's born here, and if he, let's say, gets into an accident in this particular place, he has all the rights of having been born here. No, that is not what that means. The jurisdiction in the 14th Amendment, Section 1, and we have plenty of authority to support what I'm about to say, is not territorial jurisdiction. It is political jurisdiction. And basically what it means is that if the person is subject to the jurisdiction thereof, it simply means that the parents of that child that's born here owe allegiance or loyalty to this country. That's what that means. It's political jurisdiction that the parents have ceded over to the government, and they're saying we are loyal to this government, and therefore we properly have a child born here because we are Americans.
Very well said, Richard. Very well. Very persuasive. But so how did the Supreme Court then, and I think the courts in general, take this Plyler versus Doe, which pretty much the holding was the denial of public education to students not legally admitted illegals into the country violates the Equal Protection Clause. How did then that case become kind of a precedent for birthright citizenship?
Well, this case had to do with This is a Texas case, Plyler versus Texas. It had to do with the Treasury or the legislature in Texas said that we cannot afford to pay for the education of children who are here of illegal parents. They were not cruel enough to call the kids illegal, but at least the parents were here. They were not citizens. And so what the Treasury said, that we need money from these people because we don't tax them. They're here, if you will, and they're getting a free education while we American citizens are paying through our taxes for their education. So it only makes sense under the so-called rational view of equal protection that we should have these children, or the parents of these children, pay for their education. And the argument went the following way, and the particular case, in this case, was the result of this case was that the parents, that the state of Texas was not permitted to tax these people or to charge them for their education. So their education became free as a result of equal protection. Now, let me read
real fast. I want to give you enough time so
yes.
you can read that excellent language. So stick around, you guys. Final segment coming up. We'll be right back. Stay with us. And we are back in the Legal Lounge, final segment. Thank you so much for joining us. Make sure to check out Rich's fantastic book, American Illusion of Freedom. It's available on Amazon.com, Barnes & Noble. Also, check him out on AM870 The Answer. You can find the program schedule over there on AM870.com. And Richard, I cut you off. I apologize for that, but we got to get into this we're talking about Plyler versus Doe. It's a Texas case, came out of Texas, regarding illegal immigrants and public education. And we have a great reading here.
Yes, thank you. This is part of the dissent by Chief Justice Berger, Justice White, Justice Rehnquist, and Justice O'Connor joined the dissent. I should tell you that Justice Berger was no friend of the liberals. The liberals absolutely hated this man because he believed in following the Constitution, kind of a unique idea.
Excellent writer, too. If you like Scalia's prose, you'd love Berger's prose.
That's right. Okay, so what does Chief Justice Berger say? He's describing what happened in this case and what the majority did. And so he's saying this, I'm quoting from my fantastic book. The dispositive issue in these cases, simply put, is whether for purposes of allocating its finite resources, right? The state of Texas has a finite amount of money that it receives through taxes. Whether or not a state has legitimate reason to differentiate between persons who are lawfully within the state and those who are unlawfully within the state. So that becomes an equal protection question. The distinction the state of Texas has drawn, based not only upon its own legitimate interests, but on classifications established by the federal government in its immigration laws and policies, that it is not unconstitutional to make that distinction. Now, the court, Justice Berger goes on to say, however, the court acknowledges that except in those cases when state classifications disadvantages a suspect class or impinges upon a fundamental right, the Equal Protection Clause permits a state substantial latitude in distinguishing between different groups of people. Now, let me just pause that for a second. When it comes to equal protection, the government can use what is called rational basis. If there's any reason for why the government wants that law, it will be accepted as constitutional. However, if the law that the government is proposing happens to fall within what is called a suspect class or a fundamental right, then the government has the burden to show why that law should be okay, why it should be constitutional, and why the people should have to follow it. So what Judge Berger is simply saying here is that's the standard. And Texas has already said we need this money because we need money to survive. Now, here's the best part. Moreover, the court expressly and correctly reflects any suggestion that illegal aliens are a suspect class or that education is a fundamental right. So he's saying, okay, we know what the rules are. If it's a suspect class or a fundamental right, then the law is probably unconstitutional because the
strict scrutiny.
Government has the obligation of proving that they're right. However, we've already said that illegal aliens and, oh boy.
That illegal aliens are not a suspect class, right?
Well, illegal aliens are not a suspect class, and that education is not a fundamental right. Yet by patching together bits and pieces of what might be termed quasi-suspect class and quasi-fundamental rights analysis, the court spins out a new theory custom-tailored to the facts of these cases. So basically what they're saying is the court just made it up.
Made it up.
They knew that Texas was right. They knew they should have used their so-called rational basis test, but they instead made up their own.
And it was a wholly wrong decision. In our
Absolutely.
opinion. All right, Richard, we're out of time. Thank you so much. We really appreciate it. Make sure to check out Richard's book, fantastic book, America: An Illusion of Freedom. It's available on Amazon.com, Barnes & Noble, and on iTunes. And we'll see you guys next week here in the Legal Lounge.
Okay, Mike.